Hi, my name's Anna. I'm Head of Politics and Law at Newcastle Sixth Form College, and I wanted to go through the definition of the offence of murder. Murder is probably our most serious crime, and it's probably a crime that you've already heard of before you even studied law. The difference is really understanding how murder works and being able to explain it well. It's a popular exam topic, so to be able to be ahead of the rest of the crowd, you need to be able to break down the definition in quite a lot of detail and back it up with case examples. Now, there's not many case examples that really directly relate to murder, so you might have to think wider in the syllabus that you've studied to be able to give some examples. Before we go into the actual definition of murder, just a few things that we need to be able to say in our introductory paragraph. First, murder is a common law offence. That means it's never been written down in an Act of Parliament, and it's been essentially shaped by judges when they've made their decisions in courts. It's quite unusual that our most serious offence is actually not made by Parliament, because Parliament is a representative of the people and they tend to be the ones that shape crimes, and certainly nowadays that's the case. The other thing to mention about murder is its sentence. This tends to cause some confusion with students, so I want to go through it right at the start. Murder is the only offence in the English legal system that has a mandatory life sentence. Now, the easy way to remember that, of course, is M and M. Murder is mandatory. Now, sometimes people get confused because they ask, does a life sentence actually mean life? And yes, it does. Now, there is something called a whole life sentence, and those are reserved for the most sort of prolific, serious serial killers that we have in our society. And I urge you, look up some of the offenders that are currently on whole life tariffs. Whole life tariffs are people who will spend the rest of their lives in prison and won't be released. A life sentence, though, still affects the offender for life. It's just that they may not spend all of that time in a prison. So, a life sentence is given from a person offending up till when they die. You can't see the little crosses in his eyes, that means he's dead. So that sentence will hang over that person until they die, and it'll have to be declared for job interviews and things like that. Now, only a certain amount of that time will be spent in a prison, and that will be decided by the judge when they're convicted. So, for example, if you kill someone in a public office, like a police officer, you're more likely to get the higher end of that time in prison. Whereas if there are mitigating circumstances, so for example, it was a mercy killing to end someone's suffering, it's still mandatory life, but you may spend less time in a prison cell because you're probably less of a danger to the general public. There are lots of guidance for the judges to decide how long a person should actually spend behind bars. Now, when that person is released from prison, that's not the end of the sentence. Remember, it's a life sentence. The person spends the rest of their release on licence, and that's basically good behaviour conditions. If a person breaks those conditions of their good behaviour, they can be recalled to prison, and that, remember, lasts up until they die. So a life sentence does affect the person for life. It just may be that they aren't in prison for that sentence. Now, some crimes, which you'll look at, will have a discretionary life sentence, and it's up to the judge if they want to give that or another sentence, like a normal prison sentence or a fine or community service. But remember, for murder, it is mandatory. So if a person has committed murder, we don't care about the reasons or the circumstances. If they're guilty of murder, they must be given life. Murder, mandatory, must. Alliteration. So with that in mind, how are you actually committing murder? What would the prosecution have to show? We still use the really old definition from a man called Edward Coke. So he defined murder as the unlawful killing of a reasonable creature and being under the Queen's peace with malice aforethought, and really put the effort into learning that definition off by heart. Because if you do, that is your essay checklist. unlawful killing of a reasonable creature in being under the Queen's peace with malice aforethought. Now, as with all crimes, that definition can be broken down into two parts, the actus reus and the mens rea. So, some Latin for you there. So what we have is actus reus and, it's a bit light, mens rea. The majority of the definition describes the actus reus of murder. The actus reus is the guilty action. So this is the thing you must do to be guilty of a murder, an unlawful killing of a reasonable creature and being under the Queen's peace. The mens rea element is this very simple phrase here. Short but complex, malice aforethought. It's not enough for you to cause the unlawful killing of a reasonable creature and being under the Queen's peace alone. That would be manslaughter. For it to be murder, you must do that act with a guilty mind of malice aforethought. Then for your AO1, your application of knowledge and understanding, where you show the examiner you understand the definition, we will then break down each of these phrases in turn to explain what they mean. Let's start with the actus reus, the guilty act. What is the guilty act of murder? Unlawful killing of a reasonable creature and being under the Queen's peace. And what I've done is I've just tried to put here in very kind of simple terms for you to add in what these things actually mean. So the first is that you must have committed it unlawfully. Well, that seems strange. When can you kill someone lawfully? When is it acceptable in the law? Well, first, we have the idea, for example, of self-defense. If someone tries to kill you and you kill them, it may not be murder. We also have the defense of others. So not just self-defense, for example, if you defend your child, and to stop crime. Now, just to be clear, that would have to be a very, very serious crime for you to justify murder. So, for example, a mass bombing. If you were to kill someone to avoid a mass bombing, that could potentially be an unlawful killing. So that's stage one. Make sure there are no circumstances which would explain or allow the killing. Bear in mind here that we cannot lawfully kill out of mercy. So, for example, euthanasia is not allowed in our country. Then we must link the killing to the defendant's actions. The killing must have been caused by the person accused. Now, that has to be caused both factually and legally. Now, we'll look at causation in a lot more detail. Students tend to be fine with the first and struggle with the second. So there are two elements to factual causation and there are two elements to legal causation. Now we'll go through these in a lot more detail, but this is a good opportunity for you to put in some case law that doesn't necessarily have to directly relate to murder here. So for factual causation, you must satisfy the but-for test. But for the defence actions, would the victim have died? So for example, they didn't die of natural causes, they died because she stabbed them. Then we need to look at the chain of causation. So the chain of causation is the idea that we can link the defendant's actions directly to the victim's death and nothing else caused it, such as a doctor's bad medical treatment. Finally, it has to also be the legal cause. And this looks at whether it was too remote and unforeseeable. And we'll talk about that in more detail when we look at causation. So we have to show that the killing was actually caused by the defendant's actions to attribute the murder to them. Then they have to have murdered a reasonable creature in being, which we would now term as a human being in modern day language. Now that seems fairly straightforward. The killing of animals would not be classed as murder, for example. But there are some grey areas when it comes to human beings. So for example, what about an unborn child in the womb? What about a fetus? Well, the law has made clear that this is not classed as a human being in terms of murder. It must be independent of the mother and expelled from the womb. In other words, it has to have been born. We have a separate offence called feticide for people who kill unborn fetuses. Also, what about people who are brain dead? People whose brains are still showing activity, but essentially they are not conscious. So they're not showing signs of recognition or independent thought. They're probably being kept alive via ventilator, feeding tubes, things like that. Yes, we measure death by the death of brainstem activity. So in other words, essentially the brain has switched off. If the brain is still switched on, albeit the person isn't responding, they're still classed as a human being. So for example, if an ordinary person was to wander onto a hospital ward and switch off people's life support machines, that would be murder. A doctor can do it in certain circumstances with lawful authority. So a reasonable creature and being is a alive human being with brain stem activity, but they must have been born. Finally, it has to be under the Queen's peace. So in other words, outside of wartime. There are separate rules for when we're at war that allows the killing of the enemy soldiers. However, there was a recent debate about this in the case of Blackman, where a soldier killed an enemy who had surrendered, essentially, and was injured. Now, there are various rules under the Geneva Convention that outline what can be done during war, and the court ruled that by shooting an unarmed, injured soldier who'd given up, that was outside the Geneva Convention, and he would have been guilty of murder had he not had a defence, which we'll look at later. So that's the actus reus. Factually and legally, causing the death of a person when you don't have legal authority, and that has to be a person, so a person with brainstem activity who has been born, and it has to be outside of wartime. In other words, during peacetime. If it's in wartime, the rules are different. So if you've done that, that is the actus reus. You had to do that with the required mindset. So when you caused that death, you had malice aforethought. Now, couple of things here. I'll find a pen. Just to make very clear, what we are not talking about is motive. This is obviously something that tends to interest criminologists. Why do people kill? That's not what we're interested in. Another thing that people tend to get confused with about aforethought is the idea that it had to have been pre-planned. Not at all. You could snap and kill someone in the heat of the moment. For example, that they may taunt you, or they may lunge at you to stab you and you kill them back. All of those things would be with malice aforethought, although not necessarily pre-planned. So aforethought doesn't respond to pre-planned. It's not about motive. It is about consideration. When you caused the unlawful killing, you had considered the consequences and gone about it anyway. Now, there are 4 different ways of having malice aforethought. So this is where it gets a little complex. So you can have express direct malice aforethought. You can have express indirect malice aforethought. You can have implied direct malice aforethought and implied indirect malice aforethought. And what I've done is I've tried to put a very basic explanation of what that person was thinking. Now, express direct malice aforethought is clearly the most severe, the worst. This is where the person's main intention was to kill. They wanted to kill and they killed. Straightforward. That person had the express intention to kill. It was their main goal when they set about doing what they did. Now, this tends to surprise some people, that you can also be guilty of murder if you set out to cause serious harm to the victim. Now, you didn't mean for them to die, you just wanted to cause serious harm, but they died. That would be murder. So for example, if you say, oh, I'm going to go and beat up that person, I'm going to beat them to a pulp, I'm going to hurt them lots and lots and lots, and then they happen to die from those injuries, that is still murder. So murder is not just you wanting to kill, although it can be that. It can be where you wanted to cause serious harm and then the person died. We're really trying to discourage these sorts of behaviours in society. These, again, we're getting a bit more complex. The idea of oblique intention. It wasn't your main aim to kill. It wasn't your main aim to cause serious harm. But those consequences were a virtually certain outcome of what you chose to do. So, for example, in the case of Matthews and Elaine, they decided to rob the victim. Their main aim is robbery, not to kill, not to cause serious harm. So they did not have express malice aforethought. However, they threw him into a really wide, really big, fast-flowing river, and he protested that he couldn't swim. The two robbers walked away and left him. Now, it wasn't their main aim to kill or cause serious harm. Their main aim was to get away for their robbery. But the court said it was virtually certain that he would die or be seriously injured in that river. And the defendants knew this, they realised this, because they heard his cries for help and walked away. So therefore, the jury was entitled to decide that they had implied direct malice aforethought. Their main goal was to kill, but they had an indirect kind of side intention to kill. So, when a person is guilty of murder, they must have caused the unlawful killing of a human being under the Queen's peace, and they must have done that at the same time as having one of those four mindsets, mens rea. I hope that's clear. Thank you for watching.